A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards, and I'm so glad you're with us on the program today. We're going to be taking a look at a case dealing with the right to carry, not specifically New York State Rifle and Pistol Association versus Bruin. That's the case that is currently pending before the Supreme Court. Probably 2 months to go before we get a decision in the Bruin case. And the Bruin case, of course, deals with New York's carry laws, the may issue carry laws that for most people are probably not going to issue you a permit to carry a firearm. The average New Yorker cannot obtain a permit to carry unless they demonstrate some sort of justifiable need to carry a firearm, which, of course, the Second Amendment doesn't talk about. Right? The Second Amendment talks about the right of the people to keep and to bear arms that shall not be infringed, shall not be regulated to the point of meaninglessness. But again, we probably have a couple of months to go before the Supreme Court decision in Bruin comes down. And interestingly enough, you might recall during the oral arguments for Bruin, which were held back in November of last year, there was a lot of speculation on the part of gun control advocates that maybe the court was going to issue a very, very narrow ruling, right? Just dealing perhaps with these two individuals in New York State who had filed suit because they could not obtain a carry license. Maybe the court, so goes the thinking of the gun control activists, maybe the court was going to just, write a decision so narrowly that it would apply only to those two individuals but wouldn't touch the, underlying may issue regime in New York State. I have a feeling that those hopes on the part of the gun control activists may be fading as we get closer to this election. Reading some 2A tea leaves, this one a case out of New Jersey, where a U.S. federal judge, Frida Wolfson, has now ordered that a case challenging New Jersey's carry laws be stayed pending the Supreme Court's decision in New York State Rifle and Pistol Association. Wolfson ordered that the parties advise the district court how the Supreme Court's decision impacts the case when that decision is entered and the case is administratively terminated pending the stay. So this is a case out of Englishtown, New Jersey. That started back in August of 2021. Daniel Francisco, who is a council member there in Englishtown, is one of the plaintiffs, along with Oradell, New Jersey resident Ori Katzen. The Firearms Policy Coalition is also involved in this suit. Englishtown's Police Chief Peter Cook named as a defendant, as is the police chief in Oradell, New Jersey. The New Jersey Attorney General, who at the time was Andrew Bruck, but now is a new acting Attorney General, Matthew Platkin. And basically, the allegations are very similar to the Bruin case, that New Jersey's proper cause requirement in order to obtain a carry license violates the U.S. Constitution. Francisco applied for his permit to carry. He was denied by the police chief there in Englishtown in January of 2021 because his application supposedly did not meet the quote-unquote justifiable need criteria. Francisco first tried to appeal this decision in New Jersey Superior Court, but the courts upheld that denial in July of last year. In this complaint, Francisco and the other plaintiffs argued that they have a fundamental right to keep and bear arms, that New Jersey's gun control laws are preventing them from exercising that fundamental right to bear arms. They're requiring an application for a carry permit to be approved by the New Jersey Superior Court after it's already approved by the police is also unconstitutional, and that the state's, quote, justifiable need requirement is unconstitutional as well. Now, interestingly enough, while the federal judge issued this stay, the stay was actually requested by the acting Attorney General of New York, Matthew Platkin, who sent a letter on March 24th to Wolfson requesting that the case be stayed, noting that the Supreme Court's pending case involved New York's handgun laws and saying, quote, there is a substantial likelihood that the court's ruling in that case would govern or at least inform the ultimate result in this case. And as a result, the parties in this matter will jointly request that this case be stayed pending the disposition of the U.S. Supreme Court case. So both parties were asking for this. What's interesting to me is that the judge granted this. And again, I would anticipate and assume that the Firearms Policy Coalition, that the plaintiffs are hoping for an expansive decision in Bruin that would, in fact, implicate not just New York's may issue laws, but New Jersey's may issue laws. Massachusetts may issue laws. Maryland's may issue laws. California's may issue laws. The 8 states that still have these may issue laws that require you to demonstrate some sort of justifiable need or good cause, that this court decision might implicate each and every one of those states and the carry regimes that they currently have in place. Again, I would anticipate the FPC and the plaintiffs making that argument, but to see the defendants now make that argument too. So, well, let's kick this down the road a little bit here because, the Supreme Court might have something to say that will implicate New Jersey's gun laws. I think this is a good sign. Now, look, maybe this is just Plaquin saying, I don't want to do the work right now. Let's just kick this off. I got other stuff on my plate, so we can just, delay this until after the Supreme Court decision. Maybe there's much ado about nothing. But I just can't help but think that the wishes of the gun control activists, hoping desperately that perhaps the Bruin decision will not amount to much, is in fact just wishful thinking. And that when the Supreme Court's decision comes down, likely in early June, that we will get a meaningful decision that implicates not just the infringement on the right to keep and bear arms in New York State, but again, the very mechanisms of these may issue laws that prevent average everyday citizens from exercising their constitutional rights. I'm going to see this as a good sign. I think you should too. All right, let's turn our attention to today's armed citizen story. Oh, speaking, by the way, of the right to carry, before we move on to today's armed citizen story, our good deed of the day, our recidivist report, we should mention that Governor Ron DeSantis called for the passage of constitutional carry in Florida's special legislative session. And that's big news because Florida's constitutional carry bill went nowhere in the regular session. Did not even get a committee hearing, didn't even have a Senate co-sponsor. So I think this is really interesting that Governor DeSantis singled out constitutional carry as one of those bills that he wants to see pass in the special session that he's calling. I don't know that all of a sudden now that constitutional carry is assured of passage, but this is a very good sign. This is not just Governor DeSantis making sure, I'd sign it in response to a question from reporters. This was Governor DeSantis specifically addressing constitutional carry as an issue that he wants to see the legislature work on in this special session. Now the question becomes, okay, what's that vehicle going to be? Is it going to be the bill that was authored by Representative Anthony Sabatini, the bill that could not attract a Senate co-sponsor, that couldn't get a committee hearing, in part from what everybody seems to say is Sabatini's rather caustic relationship with his colleagues? Or will you see another Republican introduce a new constitutional carry bill, one that might get the support of their colleagues? Again, there's still a lot of moving pieces there in Florida in terms of the fight for constitutional carry. But, a couple of weeks ago, I would have said, no way is constitutional carry happening in Florida this year. The crossover deadline has passed. There was no committee hearing held for this bill. Now, thanks to Governor DeSantis' comments, I think you have to say that the prospects for constitutional carry have been revived. Although, again, I don't think that that bill is assured of passage yet. If you are a Florida gun owner, I would strongly encourage you to contact both your state representative and your state senator and urge them to get on board with constitutional carry, no matter what personality conflicts might come into play, no matter how much you might like or dislike a fellow lawmaker. The important thing is to get a good bill to the governor's desk so it can become a great law in the state of Florida. All right, now let's turn our attention to today's armed citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Albuquerque. I think this is the second recidivist report we've had in Albuquerque just this week. Man involved in police shootout charged with murder of a security guard. Yeah, this from KRQE, who reports that the Albuquerque Police Department involved in a shooting on Tuesday morning. They were in the area near the Ambassador Inn. When officers were patrolling the parking lot, they were alerted that an individual was down and had possibly been shot. It turns out that individual was pronounced dead on the scene. Police found the body of hotel security guard Daniel Mora there in the parking lot. The 38-year-old man was killed, allegedly by a man in a gray hoodie. Surveillance video shows that man in a hoodie immediately started shooting Mora, who was just making his rounds. The suspect then fled the hotel on foot. Officers identified a suspect who carjacked him at gunpoint and then led officers on a chase, crashed into two patrol cars. Albuquerque Police Chief Harold Medina says during the pursuit, officers indicated that a firearm was flashed, and then when the vehicle came to a stop, officers got into a foot pursuit with the suspect. At that point is when officers discharged their firearms. 44-year-old Donovan Bookout allegedly fired several times at officers. When officers fired back, suspect wasn't struck, neither were the officers. Bookout ultimately surrendered, was taken into custody. And police say that he has a lengthy criminal history dating back to 1996 when he was arrested for an aggravated assault charge. But despite a laundry list of arrests, there aren't nearly as many convictions in Bookout's criminal history. In 2014, for example, Albuquerque police arrested Bookout for shooting a man in the leg. Those charges were later dismissed. In 2015, Bookout was allegedly upset that his dad would not activate his cell phone, so he carjacked a woman at gunpoint. I'm not sure how one leads to the other, but whenever that incident came to an end when Bookout hit another car in a power pole, but state and federal charges were dropped when he was ruled incompetent to stand trial. Now, yeah, I'm confused here. Because if somebody is not competent to stand trial and yet they are accused of committing a violent crime, one would think that they would then be taken into custody and held in a inpatient mental facility until either A, they are found competent to stand trial, right? Or B, they no longer pose a danger to the community at large. And yet, it doesn't sound like either of those things happened, because Bookout earlier this month had a warrant issued for his arrest for opening fire at Motel 6 in Albuquerque back in February. Now he's facing more charges, including murder. So, arguably, Bookout still posed a threat to the community. So why was he out on the streets? Why had he not faced consequences for that carjacking back in 2015? Now, I will say, look, it's entirely possible. That was almost 7 years ago. It's entirely possible that even if Bookout had gone through the criminal justice system, he would have been given a plea deal. He would have already been back out on the streets. But again, this is just really concerning to me. And you've got a guy with a criminal history that dates back 25 years, violent criminal charges, and yet it seems very few consequences over the decades. All right, today's armed citizen story from Akron, Ohio, where a 74-year-old shot a suspected burglar inside their home on Tuesday morning. Incident described as a home invasion. Police got the call about 7:30 Tuesday morning. Again, about a break-in in Akron. Police said they found a 16-year-old inside the home with multiple gunshot wounds. Police gave the teen first aid until he was transported to Akron Children's Hospital. Last report, he is listed as stable and is expected to recover. Police say actually he could be released from the hospital this weekend. The homeowner told authorities that the teen forced his way into the home. The 74-year-old man confronted the burglar at one point, fired a gun at him, striking him multiple times. Police say the homeowner not hurt. The investigation's ongoing. So far, no charges have been filed. This would appear to be a clear-cut case of self-defense. Ohio has a castle doctrine, a law that says you are allowed to protect yourself inside your home. And if somebody breaks into your home, you can assume that they were there with nefarious purposes and weren't there to give you candy. So if the evidence backs up the account of the 74-year-old homeowner, I'd expect that no charges will be filed against the homeowner. The 16-year-old who broke in, on the other hand, yeah, he's going to get his day in court. And finally today, our good deed of the day. Back to New Mexico, where a state police officer and an employee of the New Mexico Department of Transportation in the right place at the right time, willing and able to do the right thing to help save a grandmother and her two children from a burning car on the side of the interstate. Yeah, as somebody who has dealt with a car fire Personally, I am always compelled to share these stories because I know how quickly it can go from, hey, is there something wrong with my car, to my car's on fire, just in a matter of seconds. So according to the Mexico State Police, an officer was traveling eastbound on I-40 near Pruitt, New Mexico on Friday when he came across this vehicle on fire. It was a car being towed by an RV. He ended up calling for assistance while officers were waiting for fire crews to arrive, because, again, this is, as our friend Selena Zito would say, in the middle of somewhere, but a pretty remote area. 2 officers and a New Mexico Department of Transportation worker shoveled dirt onto the vehicle to keep the flames down. During that time, the DOT worker was also able to disconnect the RV from that car and move the RV so that it was not impacted. Firefighters later arrived, put the fire out. The grandmother and her grandchildren are okay. They've got a heck of a story to tell the rest of the family. But again, thanks to the quick thinking and the fast actions of that police officer and the employee of the New Mexico Department of Transportation, everybody was safe and sound. All right, that is going to do it for this edition of Bearing Arms Cam and Company. I want to thank you, as always, for being a part of the program. Thank you. It does mean a lot to us. I would also encourage you to check out BearingArms.com throughout the day, where we are covering even more of the latest Second Amendment news and information that you need to know about. If you like what you see, you can always become a VIP subscriber as well. Just go to BearingArms.com/subscribe. Use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. We really do appreciate your support for our independent pro-Second Amendment journalism. So as our way of saying thanks, we're going to give you exclusive content, news stories, analysis, information you won't find anywhere else, because your support really does make a difference. And it really does matter. Hope you have a great rest of your Wednesday. We'll see you back here tomorrow. Until then, be well, be safe, and be free.